All right, we're going to get started. So, you know him, you love him. He is Denver's best libertarian lawyer, longtime LOTR guest, and generally good dude, David K. Williams, here to talk about the Supreme Court and the supreme errors of the Supreme Court, which there are a lot. So I hope we cover every single case, every case they've ever ruled on. Give it up, David K. Williams.
Thank you very much. Thank you. So, I am a lawyer, but don't hold that against me. I used to do some exciting things just by way of introduction. Back in North Carolina, I went to the University of North Carolina undergrad and law school. So North Carolina is now ranked number 3 in the country, and they should be able to beat Duke at home, with or without Zion Williamson. It doesn't matter. So that'll be happening on Saturday. And so back then, some of the exciting stuff I did, I represented a couple people on death row back there, did some of their appeals, actually got to argue before the North Carolina Supreme Court on the death penalty case and won. Did federal criminal trials. I was on the appointed list, so people that couldn't afford attorneys, I was one of the people that got appointed. Highlight of that was a 3-week-long federal jury trial in a drug conspiracy case. That was the exciting stuff. I don't do the exciting stuff anymore. Now I do social media, so follow me. I gotta pimp this out, that's why it's up here. My website is bluecart.net, Twitter at bluecart, facebook.com/bluecart. So check that out, pump those numbers up. I'm not quite the Khloe Kardashian, but that is my goal. I need to get up quite that high.
Well, you gotta.
Bikini photos.
Show something!
Right, exactly. Well, speaking of Khloe, Dogecoin, well, is Kanye West still a thing? That was a thing, Kanye West. It was a thing, it really was. I guess it's still not around anymore. So check those out. And so what I do now is I represent small businesses mostly, government compliance, contract review, that type of thing. So if you have any of those questions, let me know. Holla at me at Twitter or Facebook. And the other social media thing I do, and this speech or this presentation was kind of inspired by a podcast I do now. I was asked to do this by some folks at the Launchpad Media, a group of libertarian/anarcho-capitalists. So they wanted me to do some stuff on the law, and so that's where that logo comes from. So I've done, tomorrow will be number 26. They are mostly Supreme Court cases. I've done a few other ones that aren't Supreme Court cases. But famous ones, Marbury v. Madison, McCulloch v. Madison, all of those. Miranda v. Arizona will be the one that comes out tomorrow, so we'll talk about that. And so I enjoy the academic, philosophical discussions about these things because I think it's important. But I also like to try to keep things, or bring it down to a practical level. And so this next thing I want to show you, a lot of you have probably seen it. It's a 1-minute long commercial and when I first saw it, I thought it was like just a YouTube joke. But these are actual lawyers. And no, this is great. So as you know about Miranda, that's where you hear you have the right to remain silent and all that. Well, that's one thing to know, right? And we all should know that. But this example, I think, really brings that home from these two lawyers. They're actually called the Pot Brothers. They're actually brothers. They do marijuana-related law out of California. So we can hear it.
Mark and Craig, Pot Brothers at Law. We've been warning people, if you are working for an unlicensed dispensary, an illegal dispensary, and it gets raided, you need to shut the fuck up. If you shut the fuck up, you have a good chance that we can make the case go away. Case in point, 3 employees of an illegal shop were busted during a raid. 2 of them said, oh, I'm just volunteering here. The 3rd guy shut the fuck up, and the DA did not prosecute the guy who shut the fuck up. They can't prove what you were doing there. If you're a customer, patient, you walked in to go to the bathroom, they don't know. You gotta shut the fuck up, and it's Shut the Fuck Up Friday, so review the script. What do you say when the cop first pulls you over?
Why'd you pull me over?
And when he keeps asking questions?
Not discussing my day.
And they ask more questions?
Am I being detained or am I free to go?
And if detained, what do you say?
I invoke the 5th.
And then what do?
You shut the fuck up.
Shut the fuck up Friday. Never answer questions when the cops
Have
ask.
safe holidays.
Tip of the cap.
I think that's much more effective than a Miranda warning.
We promise not to say that to you, Dave, during your presentation. Shut the fuck up!
Oh, I've heard it, believe me. I've heard it. So, and check out the podcast. If you go to bluecarp.net, there's a link there to the podcast, which is at launchpadmedia.com. So you can check out some of those cases. Yep. Don't need to do that
Mark and
again.
Craig, Hot Brothers at Law. We've been warning people, if you are working...
It's worth watching.
Yeah, exactly. There we go. All right. So whenever I talk about the Constitution, especially to a group like this, I've got to talk about Lysander Spooner's quote. So I know most of you know this because I know the crowd. But whether the Constitution really be one thing or another, this much is certain, that it has either authorized such a government as we have had, or has been powerless to prevent it. In either case, it is unfit to exist. I get that. I understand that. And I know that's what a lot of people will say. Anytime I start talking about the Constitution, they go, well, this Constitution is useless. That's what Lysander Spooner believes. I get it. But the Constitution is still there. The U.S. Supreme Court still talks about it, still pretends to at least put some pretense into abiding by it. So, notwithstanding Lysander, and I'm sympathetic, I get that. There are still things that it does. I think it's important to understand them, to understand where they're coming from, and how they've bastardized the language that's right in front of us. So, notwithstanding Lysander, let's talk to them about the Supreme Court and some of their decisions. Starting these podcasts and go back and reading these cases, John Marshall Harlan, his grandfather was the first John Marshall Harlan. The first John Marshall Harlan was the sole dissenter in Plessy v. Ferguson. That was the case that the 8-1, that guy's grandfather, John Marshall Harlan, the original, wrote the sole dissent. And in that case, that's the one that came up with the separate but equal doctrine after the 14th Amendment. Plessy was a black man in New Orleans. The state of Louisiana had put out this statute that said any train operating within the state, not interstate at all, within the state, because back then they still took the Interstate Commerce Clause seriously. So this was within the state, had to have separate facilities for black people and white people. Plessy said, no, that's a violation of the 14th Amendment, equal protection, privileges and immunities, all of that. Well, the Supreme Court, 8-1, said, no, that's cool. You can still be separate and equal. That's where that doctrine came from. Now, that was overturned about 60 years later in Brown versus Board of Education. So that's no longer there, but Plessy v. Ferguson is an important case to know. It was interesting to me looking up the facts, because to me, you can read the language, the philosophy, the big words, the Latin that the Supreme Court uses, but to me what's important is who these people are. John Plessy, for example, and he was just a guy who lived in New Orleans. He wanted to defeat this law, and he had some people with some money that were willing to help subsidize this lawsuit. So he did this on purpose. He said, look, I'm gonna ride this train and not go to the black section. I'm gonna ride, kind of like Rosa Parks, right? And he rode it from New Orleans across Lake, or around Lake Pontchartrain. And that's where he was arrested. He refused to move back. And it went all the way up to the U.S. Supreme Court, and they said, nope, the Louisiana law is fine. So that gets us back to John Marshall Harlan II, who was a Supreme Court justice just about 50 years ago, in the 60s, 70s, that era. So this is a great grandson of the sole dissenter in Plessy v. Ferguson. Most of the errors, a whole lot of the errors that I see are explained right here by John Marshall Harlan II. And he said, these decisions give support to a current mistaken view of the Constitution and the constitutional function of this court. This view, in short, is that every major social ill in this country can find its cure in some constitutional principle, and that this court should take the lead in promoting reform when other branches of government fail to act. The Constitution is not a panacea for every blot upon the public welfare, nor should this court, ordained as a judicial body, be thought of as a general haven of reform movements. If only we actually did that, we'd be a hell of a lot better off. But that's why we've had so many errors. And he wrote this, as you can see, in a dissent. The other justices didn't agree with this. They were going about and redeveloping society in the way that they thought would be better, using the Constitution as an excuse. Now, Reynolds v. Sims in 1964 was the case, anybody have any idea? That put into the Supreme Court jurisprudence, became a doctrine. You're hearing about it now with the national popular vote. This is one of the places that really got momentum. Because this case was about state legislatures and whether or not they could have a system based on the U.S. government. Because every state gets 2 senators, right? And the representatives are based on population. Several states said, you know, we're going to give every county 1 or 2, depending, senator, and everything else to be divided up by population. And, hey, the U.S. government does it. Why can't we? We want to do the same thing. Well, in this case, the U.S. Supreme Court, contrary to John Marshall Harlan in his dissent, said you can't do that. We don't care what the federal government does. You can't do that because it's not one person, one vote. Where is that, right? Where is that in the Constitution? Well, they said it goes back to the equal protection of the laws, and they made up a bunch of stuff. All right? So I don't see any way you can take the composition of the U.S. Senate as it is, where Wyoming gets 2 senators and California gets 2 senators, and say somehow when states do something similar, it's unconstitutional. But that's what they did because they didn't like that idea. They didn't like the idea of some rural county having just as much representation in one half of the state legislative body as the other half did. But the overall point is this idea that, hey, we see something wrong, we don't like something, we think something is unfair, can we bring a lawsuit to change it? Because getting the legislature to do something might be impossible, or really, really hard. Because we got, like in Colorado, we've got 100 legislators, 65 representatives, 35 senators. It's a lot of people we got to convince, and he's half of them, 51, that's a lot of people. But if we can get a federal judge, one federal judge, that might be easier, right? And a lot of people do that type of thing because of what John Marshall Harlan pointed out. People see the government, the judicial system, and the federal judges at this local level are just part of the U.S. Constitution, part of the steps to get up here, right? People see social movements. They see the government judicial system as a way to advance social movements, regardless of what the Constitution actually says. So we'll talk about some of those. All right. Now, this first one I want to talk about, I'm cheating a little bit, because this is supposed to be the supreme errors of the Supreme Court. This was actually a 10th Circuit case. This came out in 1999 when I was still back in North Carolina doing federal criminal cases. So it meant a lot to me when I was doing this at the time. Now, it's funny because who knows what circuit we're in right now? Yes, sir.
It's the 10th Circuit, and a real idiot wrote the decision in that case.
Well, you might disagree with me then.
No, not the first decision. The
Oh, got it. Okay, got it. Yeah, we'll go over that. That's very good. So, U.S. v. Singleton involved a Kansas case. Kansas is also in the 10th Circuit with Colorado. And it was a drug deal. This mule, basically, this young lady, Mexican American, was paid money to drive from California to Kansas with drugs. She got busted. She got caught. Right? As part of her trial, they had some other people that had already been convicted that were going to testify against her. And this happens every day. Every day in every court in this country, in every county, every jurisdiction. The government, either local government or the U.S. attorney at the federal level, will go to somebody like that and go, okay, you're already in jail for whatever, 20 years. If you can give us some information about this mule and help us convict her at trial, we'll cut 5 years off your sentence. We'll recommend to the judge. Only the judge can do it. But this is all part of the procedure. So Singleton and her attorney said, wait a minute, you can't use that guy's testimony because of this statute, 18 U.S. Code, section 201C2. It says, that statute punishes, quote, whoever gives, offers, or promises anything of value to any person for or because of that person's testimony. So to all of us in this room, that means if we go up to somebody and go, hey, $10, just testify the truth, okay? We've just committed a felony for $10, $20, $50, whatever it is. If the U.S. attorney goes up and says, okay, I'm gonna give you 10 years of your life back. The attorney for Singleton said, you can't do that. If I can't offer somebody $50 to tell the truth, you can't give somebody 10 years off their life back. And the original 10th Circuit opinion, which is 3 judges, agreed, all three of them. Said, you're right, that says what it means. You can't give somebody something of value for testimony. That's not hard to read, right? 3 judges agreed with that. Well, that sent the entire law enforcement community in the entire United States into a tizzy. So they immediately appealed to what they call the entire Tenth Circuit, en banc is the Latin for it. And as part of that, the total Tenth Circuit said, oh, we're putting a hold on this until I'll get to hear the whole thing. Well, the Tenth Circuit overruled and said, that doesn't apply to the government. That's what they said. That's what they said. It doesn't apply to the government. They can do that. You can't offer $50, they offer 10 years. So my mistake, or what I consider the supreme error, is the U.S. Supreme Court refused to hear that. They let it stand. Yes, sir.
You should add to your talk some quotes from the case,
Oh, yeah.
including the quote where they say the anti-bribery statute doesn't apply to prosecutors.
Right, absolutely.
That's the words they use.
Right.
They also
Yeah.
said it was akin to the divine right of kings, the right of the government to bribe witnesses.
Yeah, absolutely they did. So check out my podcast, because I go into all those details. I read some of that on the podcast. It's the very first one I did, because actually when I first started doing it, if you remember, one of the people that were flipping, might have been Cohen back in the early days of that whole Trump thing. Trump was like, oh, he's flipping Cohen, right? He's being offered time off his sentence to testify against me. And that made me think about this case. And I'm like, well, you know what? I don't like Trump, but he's right about this. Government offers people time off their sentences all the time. So, very first one, episode 1, was about this case. So the error there is the U.S. Supreme Court said, yeah, whatever, we're not going to hear it. All right. Qualified immunity, the entire concept of qualified immunity. It basically keeps someone who's been, or had their constitutional rights violated by the government from getting any redress. So we start off with this federal statute, 42 U.S.C. 1983, passed way back in 1871. And if you ever hear about like a prisoner that's been beaten or something like that, and they bring a civil lawsuit, it's probably under Section 1983. That this is the provision that Congress passed that says every person who, under color of any statute, regulation, etc., subjects or causes to be subjected any citizen or other person, not just citizens, right, to the deprivation of any rights, etc., shall be liable to the party injured, etc., okay? So if you subject someone to having their constitutional rights abridged, shall be liable, right? Again,
Just words.
not hard to read, right? Not hard to read. Yeah. And there are successful 1983 cases, but this doctrine makes it a whole lot harder. But then, in a case involving the whole Richard Nixon scandal, this is where it first came up, and it's been made worse since. But the case of Harlow v. Fitzgerald in 1982. The Supreme Court, this was an 8-1 decision, so, and the one dissenter didn't think qualified immunity went far enough, okay? So Harlow v. Fitzgerald said that the recognition of qualified immunity defense reflects the need to protect officials, government officials, who are required to exercise their discretion and the related public interest in encouraging the vigorous exercise of official authority. That is one of the scariest sentences I've ever read.
We're just being vigorous.
There's a public interest in encouraging the vigorous exercise of official authority.
Jeez.
That's, Orwell couldn't write that.
Who doesn't want to be vigorous?
But, so that is the beginning of qualified immunity. There's a whole lot of details to it, but basically, if a government official doesn't know they're violating your constitutional rights, don't worry about it. That's what it's become, anyway. David French, who writes for the National Review, just 4 or 5 months ago, wrote an article about any qualified immunity. And this criticism is not just him. There are other federal judges at lower levels that address or have the same idea. They've written about it. But a lower court judge, a court of appeals judge, can't do anything because they've got to do what the U.S. Supreme Court says. But this is the basic idea. So at Section 1983, that's the statute we looked at first, is a law designed to protect citizens and help them secure their rights. It was not designed to protect the, quote, vigorous exercise of official authority, but instead to restrain that authority. Judges have defied Congress. The U.S. Supreme Court justices They've granted lawless officials countless free passes for unconstitutional behavior. And David French isn't some Harvard liberal law professor. If you know, he writes for the National Review, right? He does have some libertarian tendencies, although I wouldn't call him a libertarian. But at least here he's pointing that out. And I think that is what we have to remember. Because what happens, in my view, is that all too often, it's like the oracle at Delphi. The Supreme Court speaks in tongues, and us mere mortals can't understand it because we didn't go to an Ivy League law school. We have to like, oh, well, if that's what the Supreme Court said, then it must be true. And that's wrong. The Supreme Court is reading English that you and I can read in the Constitution, but they do stuff like this, and we don't have to accept it. We shouldn't accept it. So this is one of those examples.
So David, what's the
Yes.
remedy? When you say we shouldn't have to accept it, what's the remedy?
To the extent you can, you nullify it.
The guillotine, I think.
Well, I won't go that far, but some people will. The first step is to be aware of it, right? Because if you're not aware of it, nothing's ever going to change. So, what's like the 12-step program? You have to admit you got a problem. If you don't admit you got a problem, you ain't ever going to change. Far too many people just go, "Oh, the Supreme Court said that, therefore it's right," and that's patently absurd. Yes, ma'am.
What about redress of grievances?
It's listed in the Constitution. It doesn't have any real effect to anything. Redress of grievances. It means you can complain. It doesn't mean they're going to listen to you. Basically, is where that comes from. The bottom line of that. Yes, sir.
So you mentioned at some point that the lower courts can't basically disobey.
They can't overrule the Supreme Court.
Why is that? Like, why? Because obviously I can disobey. There's consequences. Why can't they disobey?
Well, no, that's a great question. Why can't a U.S. District Court judge just ignore this? He could, and then the 10th Circuit Court of Appeals is going to overturn it. I mean, that's the reason. They know they're going to be overturned. Judges don't want to be overturned. I mean, there might be some example somewhere where they don't care, but even federal judges who are appointed for life, right? They don't want to say, the U.S. Supreme Court is wrong, I'm going to say they're wrong, and then I'm going to get overturned. And a big part of that is that they are part of the system. Even if they disagree with the U.S. Supreme Court, they are part of the system, and they know that the system exists by doing what they're told.
I've heard that Ninth Circuit gets overturned a lot.
They do, the most overturned circuit, yes.
So maybe that's the only, like, an exception to the rule.
No, they're just even worse than the U.S. Supreme Court. I don't think they're doing it on purpose to make any real points. Somebody might argue that, but I just think they're even more activist, is my opinion. Yes,
So
sir.
David, I don't mean to be a stickler, maybe
Please do.
I don't mean, maybe you'll get to it, but if there's something that's just abusive or intolerable and society doesn't like it, are you suggesting that we use representative democracy to change elected officials? Are you suggesting constitutional amendments? I mean, there are processes built into the Constitution should they become egregious enough. What's your preferred, or maybe there's lawsuits itself, activist lawsuits on the other side.
If anybody wants to do any of those things, I'm not going to discourage them. What I think we need is, for example, like the local county commissioners that have recently said, we're not going to enforce the laws that a higher body has told us we have to enforce. We need more sheriffs to say, no, we're not going to do that.
So that's a version of nullification then.
Absolutely. Yes. Let me keep going because I've got a couple more I want to hit, and I'll try to speed it up just so you guys can get an idea about some of these other cases. And again, these are just some that have struck me over the years. Wickard v. Filburn.
The worst one.
Yeah, I think this is the worst one of all time. I really do. There's some really bad ones. Roscoe Filburn was an Ohio farmer outside Dayton. I just like those little details, right? He was fined $117.11 in 1941. And I looked it up. I didn't change it for 2019. I got to do that. It can't be too much more. $2,000 in current money. Because he violated one of the FDR Congress central planning provisions about trying to keep prices at what they thought was a correct level. They're central planning, right? The federal government was trying to central plan wheat and a bunch of other things. But with Roscoe, it was wheat. And he said, I'm going to grow more than you tell me I can grow. This little government agent says I can only grow so much. I need more than that. And I don't sell it. Roscoe, I don't sell my wheat. I use it on my farm to feed my livestock, and I use it myself, and I use some of it for seed. I don't sell it. So not only, it's not commerce, and it's certainly not interstate, it is staying right here. And the U.S. government, the Congress, and the President said, no, under the Article 1, Section 8 of the enumerated powers that the federal government has legitimately, one of those is right there. The Congress shall have power to regulate commerce among the several states. Roscoe Furman said, I'm not selling anything, it's not commerce. One. Two, it's not going to another state, it's not among the several states. That's shorthand, it's called the Interstate Commerce Clause. All right? That can't be any more obvious. I didn't go to an Ivy League law school, so I don't understand the Delphi, the Oracle at Delphi, right? But the Oracle at Delphi is full of crap. And this is what they've done. All right, but this is what the Supreme Court said. This is in the opinion. The commerce power is not confined in its exercise to the regulation of commerce among the states. That is exactly the opposite of what it says. The Congress shall have power to regulate commerce among the several states, but it's not confined to that. The entire point of the enumerated powers is this is what the federal government can do, nothing else. That's the entire point. That's what it says. It's not in Swahili. We can understand this. But these Supreme Court justices wanted more government power. They wanted central planning. So they wrote that. And it is just as wrong as if they had said, the sun is the moon. We wouldn't accept that, but we accept that. It's exactly the opposite. It is an amendment to the U.S. Constitution. And nobody knows this. I mean, almost no one knows this. They just go, oh, well, Congress can do whatever they want. This is basically the beginning of the drug war as well. Because before this case came out, when we had prohibition, we had the decency to pass a constitutional amendment. Because Congress can't regulate the sale of alcohol within a state. They had the decency to understand that. And they did it. They passed an amendment. Good for them. They repealed it, but they at least went through the motions. They had it for, 12 years or whatever it was? When this came out, the war on drugs, did we have a constitutional amendment? No. We just had Congress say it's illegal. Because of this case.
Well, drugs are bad. So.
Drugs are bad, exactly. So this was the end of federalism. You know, the idea that there's separate powers. Federal government can do this, everything else is up to the states. Well, this was the end of it. All right, Kelo versus City of New London. Another blatant amendment to the U.S. Constitution by the United States Supreme Court. 5-4 decision, eminent domain. The Institute for Justice represented the plaintiffs. I wanted to throw that in there because that's a great organization. And what happened here was the basic holding of the U.S. Supreme Court was that the government can take your property, but they got to pay you for it, but they can make you sell it. The Constitution says that it's got to be for a public use. Well, the U.S. Supreme Court said, well, if a local government wants to sell your house to a commercial developer, they can do that because the commercial developer is going to pay more in taxes than your house. So that's a commercial, or that is a public use, right? 5 of them agreed with that. 4 didn't, so at least we had that, right? And this is where I like to put this human connection to it. Suzette Kelo, this is from the case. She lived in Fort Trumbull area since 1997. This case was in 2005, right? Made extensive improvements to her house, which she prizes for its water view. She didn't want to sell it. Wilhelmina Dairy was also a plaintiff in this case. The only one that's listed first is the one that gets their name in the case. But Wilhelmina Dairy was also in it. She lived in a house that had been in her family for over 100 years. She was born in the house. Her husband moved into the house and they got married. Their son lives next door. They didn't want to sell their houses. But the U.S. Supreme Court said they had to. Now, the Fifth Amendment, the applicable part, says things government can't do. Nor shall private property be taken for public use without just compensation. Public use. Now, in my opinion, what it should say, it doesn't say, but what it should say is where there's a comma, be taken for public use, that should be a period. It just shouldn't be done, period. But it's there. Eminent domain to me is one of the worst things that's in the original Constitution. That says the government can make you sell your property. But it's there. But the plaintiffs, Kelo and Wilhelmina Dairy, this is from O'Connor's dissent. The plaintiffs are saying, while the government may take their homes to build a road, nobody disputes that that's the public use, a road. Or a railroad, or to eliminate a property that harms the public, say the petitioners. It cannot take their property for the private use of other owners simply because the new owners may make more productive use of the property. This is the dissent. So the majority said, yes, they can. So I just...
Even that's crappy.
And, yeah, oh, right, no, absolutely. And this is so much of an example of central planning. Because look at that. More productive use of the property, who's deciding that? Government. Government is going to say what's the more productive use? That's right out of the Politburo. That's out of the Soviet playbook. Government's going to say what's more productive than you, the owner. It's obscene. But that's what we have. More people need to know this stuff. Ilya Soman, I think that's how you say it. He writes a lot of, you might know him. Some of you guys probably know him. Yep. Oh, another George Mason guy. So he wrote an article not long ago for the Washington Post where he said, what's going on today? Because this case was in 2005. They made Keto sell her house. They made Dairy sell her house. They made all these people sell their houses with all this history that they didn't want to sell. Today, the condemned land still lies empty. Those city officials now plan to build a memorial park honoring the victims of the eminent domain on the former site of Suzette Kelo's house. In the meantime, feral cats have been using the property. So far, at least, they have been the main local beneficiaries of the takings. But that doesn't say everything you need to know about central planning, about the government thinking they know more about the use of private property than the owner does. That's it right there. But that's what we have in this country right now. Oh, this is another thing I just wanted to, it just aggravated me. The majority use this phrase all over the place. It's a carefully considered development plan. Therefore, we're going to let the elected government officials institute their carefully considered development plan. Well, we see what happened. Nothing. They condemned all these houses. Their development plan didn't pan out. Pfizer, or whoever, I think it was Pfizer, yeah, didn't go through. They didn't buy it. So they tore down all these houses. Feral cats took over. That was the result of the government's carefully considered development plan. And that's right there in the Soviet Politburo.
They were carefully considered assassination too.
Yeah.
Doesn't mean it's right.
Right, exactly. So, about the public development, about central planning, goes to Hayek, one of my favorite guys. The curious task of economics is to demonstrate to men how little they really know about what they imagine they can design. That's Kelo right there. That's exactly what happened. Government thinks they know better than you do, and they don't. This is from the majority part of the opinion. When this court, the U.S. Supreme Court, began applying the Fifth Amendment to the states, and that's another issue about incorporation, but apply the Fifth Amendment to the states at the close of the 19th century, it embraced, the U.S. Supreme Court embraced the broader and more natural interpretation of public use as a public purpose. The Constitution says public use. The U.S. Supreme Court says no, it means public purpose. They changed the word. Right there, they changed the word from public use to public purpose. That's not what the Constitution says, yet the Supreme Court amended it. No. That is a usurpation of power. It's a usurpation of congressional power. It's a usurpation of state power. And they just took it. It's right there. It's like the Commerce Clause, when they just completely reversed it. Just down here at the bottom of this, again, O'Connor's dissent. The public use, what the U.S. Supreme Court has done, the majority, they're taking public use, they wash out any distinction between private and public use of property, and thereby effectively delete the words for public use from the takings clause of the Fifth Amendment. Accordingly, I dissent. There are 4 of them that joined us. But she's saying it right there. They've amended the Constitution. And that's exactly how they did it. Because there's this idea of deference to the legislature. It's another concept that the majority used. Well, how about deference to the Constitution? How about deference to people that own a house? How about deference to people that have been in it for 100 years? Nah, we're going to have deference to the legislature instead of to the Constitution. All right, Salinas versus Texas. All right, we're wrapping up here. There's a lot more, but I wanted to squeeze this one in. This was from 2013, not that long ago. Again, a 5-4 decision. The Fifth Amendment's privilege against self-incrimination does not extend to defendants who simply decide to remain mute.
How's that possible?
You're asking me. You're asking me. So, what happened in this case was there had been a murder, shotgun murder, horrible crime, right? And they had a suspect. They brought him in. He agreed to answer questions. And then, so he was talking with the cops. And then they said, well, you own a shotgun, and these people were killed with a shotgun. Do you think we might be able to connect that with ballistics or something? And he shut up. He had been talking, he stopped talking. At trial, his lawyer said, you can't use the fact that he stopped talking against him because you have the right against self-incrimination. He doesn't have to answer that question. The U.S. Supreme Court said, you do. You can't just remain mute. You have to say, I'm asserting my right against self-incrimination. So to assert your right against self-incrimination, to assert your right to remain silent, you have to say something. I'm not making this up. You guys can read this. And this is one of my things that I try to emphasize in my podcast. I see so many people on TV, talk radio, the news, that have some passionate opinion about some Supreme Court case or something else. And it's clear they haven't read it. To me, the one thing that really jumps to my mind is Citizens United. You see these people, the Bernie, AOC, Elizabeth Warren, they talk about Citizens United is like the worst case ever because it gives to them the corporation's personhood. Well, that's not what it says. What it says is the government can't ban a documentary. That's what it says. The government can't ban a documentary. And that they've twisted it, and people just accept that, they repeat it, and that's how ignorance gets spread. So, I'm just telling you, I've read these, I'm telling you what I think. But I'm telling you, this is what I think. You read them. Because if you have an opinion on these cases based on what I say, or Sean Hannity, or anybody else, you're basing it on what you've heard, not on what it says. And that's okay if you admit it. But the people that pretend they've read it, and what's even worse is somebody on TV or the radio has got this passionate opinion, and they haven't read it. And then you and I, or whoever listens to somebody else with a passionate opinion who hasn't read it, now their opinion is based on somebody else's opinion who hasn't read it either. That's just the spread of ignorance. All right, so that's the podcast. There's more there, and there's a bunch of other cases I could have gotten into, but I wanted to highlight those. If you go to bluecarp.net, there's a link there to check them all out. So that's my pimping out my social media. Any questions? Fire them at me.